Hello and welcome to Heritage Foundation. I'm Andrew Parks, the program coordinator for lectures and seminars. Thanks for joining us today in our Lewis Lehrman Auditorium. I just want to take the opportunity to remind folks attending in-house to turn off cell phones as a courtesy to those recording the program and our panelists. And those watching online are welcome to submit questions by emailing speaker@heritage.org. Hosting today's program is Alden Abbott. He's the Deputy Director of the Edwin Meese III Center for Legal and Judicial Studies and the John, Barbara, and Victoria Rumpel Senior Legal Fellow here at the Heritage Foundation. With that, Alden, thank you.
Thank you very much. Patent protection, which is specifically recognized in the Constitution, is a key property right that has become increasingly important in our modern economy. Recently, however, certain Obama administration enforcement policy actions and public pronouncements seem to suggest that the administration supports limiting profits on patents that are vital to high-tech industry, particularly in the area of standard setting. And in particular, we'll be talking about a letter the Justice Department released dealing with standard setting just last month. Does the administration's policy shift threaten to undermine innovation and growth in the American economy? A panel of patent and antitrust experts from government and the private sector will address this important question. We will hear in turn from Richard Taffet, a partner at the Morgan Lewis law firm, then Joshua Wright, Commissioner of the Federal Trade Commission, and Gregside Act, founder and chairman of Criterion Economics. I'll just briefly mention our distinguished speakers. Mr. Taffet has 35 years experience in high-tech patent and antitrust litigation and counseling. He's a leading member of the antitrust bar and active speaker on patent antitrust issues. Joshua Wright, who holds a PhD in economics as well as a law degree from UCLA, became an FTC commissioner in January 2013, was a professor at George Mason Law School, and has written extensively and is well known for his scholarship in law, economics, with an emphasis on antitrust law. Gregside Act, who's a lawyer and economist, is former Deputy General Counsel of the Federal Trade Commission, formerly served on the Council of Economic Advisors, and in his work as a top economic consultant, he advises on antitrust regulations, patents, intellectual property, royalties, telecom, energy, and other sectors to helping clients here and abroad. Let me start by turning over the podium to Mr. Taffet.
Thank you, Alden. And if it's all right, I'll speak from my seat here. I am told that we have a PowerPoint. I don't know how. Oh, there it is. There it is. So I think I've been asked to kick this panel off in some respects to address the question posed by Alden, which is standard setting in patents is government policy harming innovation. And to use the recent developments surrounding the patent policy, the new patent policy that was just approved by a standard-setting organization, the IEEE, this past month, and to use that as somewhat of a case study, not only of what happened there, and I'll review the background and how it developed, but also really to answer the question that Alden poses, which is whether government policy is harming innovation. And I would state from the outset that as of today, March 12th, the answer is we don't know yet. But the question is what's the risks and what are the likelihood of such harm occurring? And we may, my goal is to set lay the framework and foundation for addressing that by looking at the IEEE, and Josh and Greg, I'm sure, will add that into it. So let me start by just providing some background, and many of you may be well informed of and have followed the IEEE saga that has transpired since now 2 years, starting in March of 2013. But the culmination came about on February 9th last month when the IEEE's Board of Directors approved revisions to the IEEE's patent policies. These will become effective Sunday, March 15th. And while there was some commentary that these changes were clarifications of the existing policy, I think it is fair to say that by looking at the actual changes that were made, that they reflect a very, very fundamental change in the IEEE's policy, and also a fundamental change in how SSOs generally have treated the use of patents in technical standards. As I mentioned here on this slide, it's interesting to know that in some respects the IEEE, depending on your point of view, I guess, is either a trailblazer or marginalized itself, as I say, depending on which angles you come from, because those who have championed the changes that were made are the same people, the same companies, the same interests who have proposed these types of changes in other organizations. In ETSI, the European Telecommunications Standards Institute, for example, similar proposals were made. Similar proposals were also made in the ITU with respect to proposed modifications to its joint common patent policy with the ISO. And based upon the principles of consensus that are followed in those organizations, those proposals were defeated. Interestingly, that in the same week or immediately after the IEEE made its decision last month, the same issues or similar issues were being raised at other SSOs. JEDEC, which is a Semiconductor Standards Association, looked to similar types of proposals, and it too rejected these proposals based upon consensus consideration by its board and members. Same result in the NFC forum. NFC is the Near Field Communications Forum that when you go to swipe your card at the merchants and other places, how the wireless communications occur there. They too decided not to follow the path of the IEEE. So as I say, either the IEEE is a trailblazer, or on the other hand, if your perspective is different, it's really become marginalized from the norm here. I point out that the IEEE's actions, and it might be not a surprise to many of you, was taken notwithstanding rather significant opposition by global companies. And one thing that I would point out is that these issues are not limited to the IEEE. As I mentioned, there's debates in other SSOs that have been going on for years. There's litigation that's going forward that addresses the same issues, and the courts are beginning to address these. We had Judge Robart in Washington. We have Judge Davis down in Texas. The Fed Circuit's now getting involved, and the Ninth Circuit's argument is coming up in the Motorola Microsoft case. But at bottom, at least in my opinion, is that the effect of the changes in the IEEE will have, or are intended to have, an effect that will decrease the value of SEPs. SEPs are standard essential patents. And we'll go through that in a moment. And this goes to the ultimate question that Alden raises, is does government policy support such an approach, or should the market negotiations and other impacts have a role? So here's a basic overview of what the new policy will address. This does not purport to be an exhaustive review, but some of the key provisions that I think important to highlight is the IEEE's new policy will ban even the seeking of an injunction before at least the completion of a first level of appeal, which those of you who are patent lawyers or get into courts understand that could be years down the road, and it's regardless of whether the prospective licensee is a willing licensee, a non-willing licensee, however you want to define those terms. Similarly, the changes in the patent policy provides specific provisions that define what a reasonable rate will be. And for example, I indicate 3 here, that what has come to be called the SSPPU in patent litigation is identified as the royalty base. In IEEE lingo, it's the smallest compliant component or something like that. There is a provision which would cap royalties based on principles of proportionality, which is an important factor here because the policy does not say how one would calculate a cap of this nature, or how you would balance, or what kind of metrics you would use to determine the proportional value. And then one cannot take into account existing licenses that were obtained either under an explicit or implicit threat of an injunction, which is, again, something that is not driven by patent law, but is a policy decision as the IEEE determined it should be implemented. Similarly, the new policy will require licenses to component makers, even where those component makers facilitate an end product that is compliant and isn't not necessarily compliant. And finally, I point out here that there are limitations on the ability to require cross-licensing, for example, here of non-essential patents and other details. But I would encourage people to go in and look at the details of the policy. It's quite complex. There are a lot of changes, and we ran red lines, and I would think about 2/3 of the policy has changed, as well as their letter of assurance. So how did this all come to be? And this is really getting to the question at hand right now. So back in 2012, in remarks to the ITUT roundtable, Deputy Assistant Attorney General Hesse provided her 6 small proposals for SSOs before lunch. And what happened there was that DAG Hesse pointed out that there are risks perceived, potential risks, I should say, of holdup and royalty stacking, which SSOs should take into account. She also stated the position that the concept of FRAND or RAND is uncertain because the SSOs do not define typically what a RAND royalty will be. That's left to the negotiations of the parties. So Renata proposed 6 steps, which I characterized, or which I set forth here. And as you can see, whether they're agreeable or not agreeable, they're good ideas. They didn't drill down into real specificity, and the remarks really did make it clear that these were not mandatory steps that should be taken by SSOs, but they were proposals. They're non-binding. She did encourage SSOs to seek business review letters. That's what BRL stands for there. And indeed, though SSOs have taken these into consideration, she led the U.S. delegation to the ITU when certain changes were being proposed there, and the delegation, the organization, other delegations did not accept some of the proposals that were being made, consistent with the suggestions here, specifically on injunctions. So there was this process going forward, and the debate is quite rigorous, and which is in and of itself, I think, a good thing. So what happened in the IEEE is an ad hoc committee was formed under the auspices of the IEEE Patent Committee. And the purported rationale for moving forward was, well, we have these suggestions that are being made by the Department of Justice, and there's Commissioner Almunia in Europe making some suggestions also in connection with various proceedings there. So let's take a look at what's going forward. But what happened starting in March of 2013 and ending in February of 2015 was a series of proposals. There was 660 comments and objections made to these proposals, both on substantive and procedural grounds. The concepts of consensus were expressly disclaimed as being required in this context. And what's interesting, there was, and perhaps more to the ultimate question that we're being asked today, is what was presented was devoid of any actual evidence showing that the IEEE patent, I'm sorry, that the existing IEEE patent policy was raising legal questions, was ineffective in connection with the development of IEEE standards with respect to the evolution of technologies. And I think one can look, for example, to the 802.11 family of standards, which is perhaps the most ubiquitous standard right now, and it's on, I forget which version, it's like AX or AH, but it's 12, 13 versions in, and proceeding apace. There were specific requests for justifications to be offered as to the actual efficiencies that would be achieved by these changes, and there really wasn't a reason that's concrete given, but there were these statements that these are necessary to provide clarity and because of the perceived risk of holdup and royalty stacking. With respect to the open consensus-based considerations, ultimately there were a number of appeals by companies to seek to overturn the actions of the lower levels of committees. And it was said that that's not appropriate in the IEEE context because that would not let the individuals make determinations in their individual capacity, but that has the perhaps unintended consequences of allowing a closed group to be able to advance a particular position going forward. Interestingly, as this has moved forward, and I'll get into the DOJ in a minute, but the European Commission, at the culmination of these efforts, did express concern, both on procedural and substantive grounds, to what the IEEE is doing. On procedural grounds, because of a lack of consistency with WIPO principles, and on substantive grounds, the one point that they did raise was tying the royalty base into a small assailable component. And that was an inter-directorate letter that was sent to certain companies who were involved in this. So we come to the government. What the government's role is here is that, as we know, that Dag Hesse did encourage in her remarks, her 6 small things to do before lunch remarks, she did encourage SSOs to come and seek a business review letter. And what needs to be understood is to understand what a business review letter is. It's where a party can go to the government before the conduct or event that is being inquired about occurs, and ask the government, the Department of Justice, whether it has a present intent to proceed against the company if the act or conduct is undertaken. That's the concept of a business review letter. It's advisory in that regard. So at September 30th, the IEEE submitted, requested it's a business review letter. You know, interestingly, on behalf of certain of my clients, we did request a copy of that request, and it was declined, which is, I guess, just a data point. But what's interesting, and you can get the request now, it's publicly available on DOJ's site, it didn't, again, identify specific inefficiencies in the IEEE process, the existing policy. It didn't address the concrete efficiencies that would be gained. It did not even acknowledge the substantial objections which had been filed at many, many levels for a year and a half before the request was made. The request was then made to the DOJ, and DOJ issued a response early February also, I believe. But this process allows for comments to be made. Many companies on all sides of the issues went before the DOJ. Some of the points that were made by those who had been objecting all along, I identified here that, you know, from an antitrust perspective, it doesn't matter whether you follow the rules or you don't follow the rules. The question is whether there is an anti-competitive effect from conduct, or in this instance, a likelihood of anti-competitive effect. But procedural rules are important because they are a guard against the types of effects that often have been identified specifically in connection with standards development, and guard against the type of collaborative or conspiratorial conduct that the antitrust laws do prevent. So many people commented on the fact that those types of principles, which the IEEE itself considers core values of consensus, openness, due process, et cetera, were not applicable because this was a policy issue and not the development of a technical standard. I do have trouble with understanding that dichotomy, and it's unique to the IEEE. Again, people pointed out that the new policy will undermine value of patents contributed to IEEE standards, because if the value of an SEP is going to be defined simply by the way the IEEE defines reasonable rates, which may or may not be consistent with existing patent law or litigation, what may result in litigation, the incentives are to not contribute those patents to the IEEE process. And there's a consequence to that, because at this point, I think it's unassailable that technical standards are based upon myriads of patents. And the opportunity to use patented technology in standards is a positive in the sense that it at least makes available optimal technical solutions. And if there's a consensus basis upon which to adopt those standards, then industry, the market, can determine what is the best standard in those contexts. There is therefore the risk of dynamic loss, which I'm sure these folks will talk about more, because you have inferior standards which may be shorter or cheaper potentially. That's not been established either in the short term, so you get a static gain. But in the long term, because they're inferior, they have greater obsolescence, lesser performance, and less consumer attractiveness, innovation overall is going to be harmed in the long term. And there's still this issue of where's the beef? Where's the actual evidence of harm or potential harm? So February 2, the DOJ issues its BRL. Now, Renata Hesse authored the BRL. Assistant Attorney General Baer recused himself from the process. And what the IEEE says, what the BRL states is that the DOJ has no present intention to bring an enforcement action. Fine, that's their evaluation was able to determine that. But interestingly, the BRL goes further, and this is a question of going to what in Europe is often called soft regulation, or the policy, advancing a policy rather than pursuing antitrust enforcement activities. Because the BRL affirmatively endorsed the IEEE's changes rather than saying SSOs should do whatever they want, by pointing out the possibility for clarity, the possibility for lessened litigation. But on the other hand, there was no discussion of the potential risks of longer-term or dynamic loss. There's no discussion of the potential for actually more complexity. I go back to the point I made with respect to how do you determine what a proportional value will be when you have 4,000 patents that are declared as potentially essential. Some of them may be, some of them may not be, and how is that process going to work going forward? The BRL, though, as I say, pointed out what it perceived to be the justifications, and said that SSOs are free to adopt similar IPR policies again for themselves. Again, a question that I raise is this, or why was this included in the BRL, as opposed to just the conclusions based on the investigation and the facts. So the point I think here is that, and this is a concern that there's, I am sure, tremendous debate about, and is whether this action by the DOJ was really the exercise of antitrust enforcement discretion and policy, or was this reflective of an industrial policy of some sort, which has been advocated going forward, and basically picking winners and losers. And this is it's not a new debate. I remember back in the 80s when all the car companies were going out of business, and there was a whole debate: should government get into the business of picking winners and losers, and definitively, regardless of what position you are politically, the answer is no. The government should not be doing that. But in some respects, this does reflect a policy preference that the DOJ has been advocating for some time. And apparently it's not any longer consistent with the EC, but it will have certain consequences internationally. We do know, and those of you with many companies who are multinational in nature are dealing with China, are dealing with Korea, are dealing with Japan, are dealing with India, are dealing with all the emerging Brazil, all the emerging companies where the maturity of their antitrust laws perhaps is not as strong as in the U.S. and will, without a doubt, be looking to this BRL, and in my view, not properly considering what a BRL is, but nevertheless looking at it as a statement of policy from the United States, which is not the way one should look at a BRL, but that's just the natural consequence of what's going to happen. So predicting the future, the answer is I have no idea. But there have already been major players in the IEEE space who have said they are not going to submit letters of assurance to say that they will license on RAND terms under the new policy. Now, we'll see how that may wind up. There are people I know who have already withdrawn from IEEE committees because they don't want to expose their portfolios to this new policy. And if this trend actually occurs, then there's other consequences. Some people say people can walk with their feet, or vote with their feet, I should say, and go to other SSOs. Well, that's not always possible, because we can use the 802.11 context again as an example, where we're on version 15 or something, and the IEEE, I would assert, has market power in that regard, and one cannot go out and establish a new SSO to come up with inter-standard competition. So, that and see how it shakes out. We'll see what happens. On the other hand, in the two instances where the issue has come up in other SSOs immediately following the IEEE, where consensus processes were followed, similar changes were not adopted, and that may be a trend too. So the IEEE may be an outlier, and the DOJ's position may be an outlier. That's the kind of future that, as I say, I can't predict as a result. And that's all I have to say, and I'll turn it back to Alden.
Thank you very much for setting that up very nicely. Let me now turn to Commissioner Wright for his observations.
Thanks, Alden, and thanks for the invitation to be here. And Richard made my work a lot easier by walking through everything that's in the letter. So now I can assume you all know it, and there'll be a test later. I have a microphone in front of me, which means I must say, and Alden said it's going to be webcast, so I better say, the things I say next you can't hold against the other commissioners or the commission, but you can blame me. So let me start by saying a couple of things, because I want to, and throughout my comments, I think I will draw a important and I think fundamental distinction between IEEE's policy on the one hand and DOJ's business review letter on the other. I think it is a good idea for antitrust agencies to write business review letters. We call them something different at the FTC, but we are sort of engaged in this business as well. They provide clarity and stating public positions, having the government state its public positions with respect to its enforcement authority on tough questions. These are good things to do. Most business review letters or advisory opinions, as we call them at the FTC, I think give a sense of the agency's enforcement priorities. They have a sort of a transparency function and can let the world know what the agency thinks about tough questions. Using the context of a business review letter to go beyond assessing the particular antitrust risk associated with some proposed identified conduct, but instead to espouse policy views outside of the scope of antitrust is a different ballgame altogether. I agree with Richard that this particular letter does that. And by does that, I mean this letter goes beyond assessing the antitrust risk of the particular proposed amendments and delves, I think, not just its toes in the water, but perhaps knee deep and maybe shoulder deep into policy territory. And I think that's really important, and it's important because when an antitrust agency, a competition agency does that, those policy views are given the imprimatur of government support. And so when a government agency or government agencies are going to espouse those sorts of policy views, I think, my view in this, I hope it's not a controversial one, is that those policy views ought to be supported by the best available economic analysis, evidence, and so forth, that the policies are going to make the world better, not worse. Further the objectives of the agency, in the case of the competition agencies, consumer welfare, and not make those things worse. My own assessment, again, not of the IEEE's proposed amendments. I don't have a particular dog in the fight with respect to whether they are a good idea or bad idea. I may have personal views on that, but with respect to my day job, I don't care. And I don't think that it's my job to tell a standard setting, a private organization, to give management consulting advice. They can pay other people for that, and I presume that they do. So the reason I think it's incredibly important when a government agency sort of delves into the business of management consultant and micromanaging the contracts of private organizations and or espousing broader policy views, in this case on patent policy, is because the cost of being wrong for a private entity is much different than the cost of an antitrust agency, a government agency being wrong. There are limits on what private entities can do to vote with their feet. This is an issue I think Richard correctly raised. In some agencies, people can leave. There are some SSOs that might have market power, some that don't. Some firms that can leave, some firms that might be able to sponsor a new entrant. But there is some limit on the cost of being wrong for private entities. It is hard to think of a limit on the cost of being wrong for a government agency in setting antitrust policy. It applies broadly and widely throughout the economy. The effects go well beyond standard setting and go to the value of the patent system generally. That is, if there is an area to be concerned about, really being careful about getting it wrong, the rate of innovation and economic growth deriving from the patent system has got to be on your top 5 list. And so I think it's incredibly important if one is to wade their toes, knees, or shoulders into the policy-making territory, even if done through the wrong vehicle, and this is done through the wrong vehicle without a doubt, it is important to ground that analysis in as much evidence and fact as you can find. That, I think, is a separate problem with the DOJ letter, and one I will delve into a little bit of detail and try to place into some context more generally of movement in the antitrust IP space between both agencies over the past decade or so. So to start with, I think it is certainly worthwhile reiterating the point that Richard began with about the purpose of a business review letter. At the outset of the letter, and I'm going to, this is, I promise, the only part I'll read from the letter. The department seems to agree, the Department of Justice seems to agree with Richard on the purpose. Quote, the department's task in the business review process is to advise the requesting party of the department's present antitrust enforcement intentions regarding the proposed conduct. It is not the department's role to assess whether IEEE's policy choices are right for IEEE as a standard settings organization. Yet, in my view, I would probably describe about 10% of the letter as being associated with assessing the antitrust enforcement risks of IEEE's proposed amendments, and about 90 doing something else. A lot of that 90 is a general discussion of patent law. There are some patent experts inside the FTC. I know that there are a handful inside the DOJ, but we are expert antitrust agencies. We are not the expert patent agencies or contract law agencies. There's a good amount of discussion about contract law as well. Very little discussion of antitrust. And while the patent questions, and you can have fun and exciting and interesting debates, and maybe there'll be another conference to have those about how we should calculate royalty rates and whether patent damages law makes any sense. Those are important issues. Those are not issues for which the antitrust agencies are expert, and those are not the types of opinions that the business review letter process or the FTC advisory opinion process are built to do. We do antitrust. And if you search through the letter with respect to sort of looking for antitrust analysis, what is there is a little bit troubling. So what is there with respect to antitrust analysis is the following. There it is. Generally, I think the underlying intellectual foundations of what is there, Richard laid out. I think it's helpful to go through Renata's sort of earlier speech. The department has made clear, and my agency has too. I am in the minority at my agency on this particular topic, among others. But they have made clear that their view is that there is something fundamentally run amok in the SSO contracting process. The contracts are incomplete, and that's a problem. Now, all contracts are incomplete. They're incomplete by design. Economists have been writing about the incomplete contracts literature for a very long time. Oliver Williamson has a Nobel Prize for it. The insight that contracts are incomplete is not an endpoint for analysis. And the department and the economists there and those at the FTC know this, but there's been a conclusion made by the agencies that ambiguity in SSO contracts, goodness, we wish you would define FRAND with more precision, or with injunctions, their problem really isn't precision. They just want the contracts to say something different than they do. It's not really ambiguity. They would like different contract terms. I would like different contract terms with, my mortgage broker. But, there's a difference between saying the contract terms create an antitrust problem. Yeah, right? Is there some market failure to do with monopoly power that's creating gaps in the contracts that are harming consumers? If there were, that gives rise to serious antitrust concerns. And what's missing from the letter, the way I think the normal antitrust analysis would run thinking about such a problem, is the standard economics literature. You've got people transacting, they're going to sink investments, and that's going to change their incentives to behave with one another. That's good old-fashioned sort of, we can worry about opportunism and the like, and we worry about it on both ends. Right? We worry about patentee, we worry about the potential infringer or licensee, we worry about both sides. Taking advantage of one another in the contracting process, and not an antitrust problem yet, and that ultimately having some competitive effect. The way we would think about this in a standard antitrust analysis with the rule of reason would be, well, let's assess the danger of holdup on the one side. Let's assess the competitive risks associated with what you can call reverse holdup, if you like, on the other side. Now you've got competing theory. Every scientific method for a long time has said when we've got competing theories, we look to data to resolve our disputes. And the problem is there's just not any evidence to suggest that as a policy matter, an antitrust agency should favor being concerned with one of those more than another. Maybe in a particular case, right? You have clear evidence of holdup in one case, you can bring an enforcement action. The FTC has. But as a policy matter, setting a policy that systematically holdup is an issue that provides competitive risks, and indeed, I think Richard put this portion on the screen. The agency said, preventing access to injunctions for patent holders is going to reduce that risk, and so it's pro-competitive. I can say it too, but there's just no evidence for it. The effects, even in theory, go in both ways. So in terms of the type of, what we normally think of run-of-the-mill rule of reason antitrust analysis that weighs, sort of considers theory on both sides and weighs the effects, the letter just doesn't do that. That, I think, is a problem. Not just that there isn't any evidence to support the policy espoused in the 90% of the letter that's doing policy, but even to the extent that we're dressing up policy and antitrust analysis. You do a rule of reason, you do a cost-benefit analysis, and you ignore one side, I can tell you what the answer will be too. And that's really what happens, is that you don't get what the DOJ does as rule of reason in its real cases. You don't get what the FTC does in its real cases, or what a federal judge might do applying the rule of reason. Heck, you don't get what a law student would do, given a test question asking it to do the rule of reason. And I think that is a real problem. Along those lines, I mean, sort of begs the question, what do we know about antitrust law in and around the area of patent holdup? We know some really easy stuff. If you use the SSO to collude and price fix with your rivals, that's bad. Turns out it's bad and unlawful under Section 1, has been for a long time. That's pretty easy. But what we're talking about here isn't that. We're talking about unilateral conduct, seeking an injunction. The DOJ and some at the FTC for quite a while have said, if you've got a FRAND encumbered standard essential patent, then seeking an injunction violates that contract and creates an antitrust problem. Well, that's a view of the antitrust law. One thing that the letter omits is that is a view of the antitrust law that no federal court in all of the land has endorsed in the existence of the Sherman Act. Zero, not zero. It's 0.0. And that, I think, the DOJ has said in some speeches that they think maybe that they'll try out a case in this area. I wish them luck. Maybe a court will adopt that, maybe not. But recall the function of a business review letter. It is to tell our enforcement intentions. We are enforcing existing antitrust law. Existing antitrust law says in the absence of deception in the standard setting process, I lie about having a patent. You adopt my technology. And then tomorrow I raise the price and say, oh, you're infringing, and give me $1 billion, or high rate, or whatever, or mow my lawn every Tuesday. I get some sort of rents out of the process through my deception. That can state an antitrust claim. The FTC has brought those cases. It's with varying levels of success. But every federal court to touch the question, every single federal court to touch the question, has said deception's required. No mention of that in the letter, no attempt to grapple with that. And that's the antitrust question. To the extent of, whether depriving a standard essential patent holder of the right to an injunction or limiting his right to get an injunction is a good or bad thing, it is certainly not an antitrust violation under existing law. And that's the function of the letter, is to tell the world that. It doesn't do that. Instead, it says, well, probably depriving a standard essential patent holder of the ability to get an injunction or limiting the circumstances under which a standard essential patent holder can do so is good for the world in the competition sense. That may or may not be true. I'm skeptical because of my own views, but what I can tell you about the existing theory and evidence is that there's simply nothing there to support that view. If there were, I think the letter is still not the appropriate forum to say so, but these are problems on top of problems in the sense that we don't quite get the analytical framework right for antitrust, and to the extent that we're engaging in policy in the wrong forum, we're doing so without a parachute because we're largely announcing policy consequences in the absence of data. And doing policy work where the ratio of theory to empirics is sort of approaching infinity is dangerous work. And it's high-stakes work, and I think it's work that, and I think this is the thought I will close on, it is work that it is easy for the FTC and the DOJ to avoid. These are agencies with real experts and really, really good antitrust lawyers and economists that work there who can engage in these problems. And so there's just this is unforced error. There's simply no need to engage in that sort of policy making. People at those agencies, people at my agencies, and I all have different priors on, the value of an injunction or how different changes might influence the rate of innovation and so forth and so on. But my priors on that subject are, $5 should get you a cup of coffee and that's it. What we should need to make policy is better than our priors. I think we should command that. I think oftentimes the DOJ does, and oftentimes the FTC does. I think in this instance, we fall short. I'll stop there.
Thank you very much. So from what I hear you saying, Commissioner Wright, is that the letter really doesn't look at traditional antitrust analysis. It's really trying to express a policy that would tend to limit returns to patent holders. Is that fair? I'm with you other than the word tries. I'm not precisely sure what they are trying to do, but I think the consequence of the letter, without a doubt,
is that it has espoused a policy view that is suspicious of injunctions, suspicious of the role of property rights in facilitating economic exchange and innovation. It does those things without a doubt. It makes a limited attempt to dress up those views in using the words and language of antitrust analysis, but I don't think any antitrust practitioner reads the letter and says, this looks like the rule of reason that I know.
Okay, thank you. Let's now turn to Gregside Act for another, I think, economically influenced view on the letter.
The question that leaps out at me as I read the Justice Department's letter to the IEEE is, why did the IEEE think it needed to get a business review letter? As Commissioner Wright pointed out, the behavior of the holder of a standard essential patent is unilateral conduct. That's not the unilateral conduct of the IEEE. So there may be discussion about antitrust ramifications of unilateral conduct that the letter goes into. But why does the IEEE feel that it needs to get a letter, a business review letter from the Antitrust Division to provide some comfort as to its amended bylaws? And I think the answer is that what is conspicuously absent from the Justice Department's letter is any discussion of the risk of the buyer cartel problem, the danger of oligopsonistic collusion by the firms that are the implementers of the standard essential patents. And so that is what I thought was, as I say, conspicuously absent from the letter. Any discussion of the reason for why a business review letter would be requested. The IEEE's letter to the Antitrust Division did flag that issue on the penultimate page, but said we think this is an insubstantial concern. I don't agree with that, and I wrote a letter to the Antitrust Division expressing that concern. I think it's useful to put in context why it is the kinds of policy changes to the IP policies of the IEEE that Richard was talking about earlier translate into steps that would fundamentally change the price levels that would be paid by implementers of standard essential patents to holders of standard essential patents. In practice, in the disputes over licensing of SEPs on FRAN terms, the parties are typically apart by an order of magnitude or more. If you read through Apple versus Motorola, some of the other cases, you'll see it's not that they're within a single order of magnitude and they're close to converging on what is a mutually agreeable FRAN rate. They're off by a very wide margin. So if you simply rule out the possibility that a particular pricing rule will apply, you then skew the outcome by the court or the arbitral body toward one end of the spectrum. So the effect of rather technical rules about using the smallest saleable unit as the royalty base, or excluding any value from the royalty that is attributable to the contribution of the SEP holder to the standard. Those translate into huge differences in terms of the ultimate magnitude of the royalty. Okay, so this really matters. It is the result of collaborative behavior among firms that may be competitors of one another in the sale of downstream products. But whether they are or are not competitors of one another in the sale of products, they are all buyers of similar technology. And by acting collectively through changes to the bylaws of the IEEE. They magnify their bargaining power over what it would be if they were just engaging in individual bilateral transactions with an individual SEP holder. I want to say something about this trade-off between the anti-competitive concern here that I've identified and the opposing concern that is the principal focus of the Antitrust Division, that is the danger of hold-up and royalty stacking. It was 2007 when the seminal articles on hold-up and royalty stacking were published. One was by Mark Lemley and Carl Shapiro. The other one was by Carl Shapiro, Joseph Farrell, and a couple of co-authors. Well, it's 8 years later. There were predictions, economic predictions in those articles about what would happen if steps were not made to prevent hold-up and royalty stacking. What do we actually see empirically? We see no evidence of market failure. I'm talking now about the handset business, the mobile phone business, and other mobile devices like tablets. Standards in this industry are set within SSOs that are populated by repeat players, big companies with portfolios of tens of thousands of patents that have recurring interaction with one another with respect to the setting of standards and with respect to bilateral negotiations over the setting of FRAND rates. These are sophisticated companies. The patent holdup and royalty stacking conjectures, and I use that word in the sense that Karl Popper uses the word. It is a hypothesis. It is not a substantiated fact. But those repeat transactions have not resulted in market failure. They've resulted in an enormous market success. There is a smartphone, well, I should say there is a mobile phone in the hand of virtually every person on Earth. There is rapidly changing over for those consumers feature phones to smartphones. So this is one of the great success stories of technological innovation and free markets. It is not a colossal example of market failure, as the advocates of royalty stacking and patent holdup would suggest. So there's no empirical basis to support these theories that are the principal concerns of the Antitrust Division in its letter. And there are even a good number of theoretical reasons to dispute that patent holdup and royalty stacking occur in fact. Chief Judge Davis of the Eastern District of Texas, who has presided over 1,700 patent cases, had a case a year or so ago in which he said the best word to describe the theory of holdup and royalty stacking that was being advanced in the case was theoretical. I think that if the Antitrust Division were subjected to the same standard that an expert witness is subjected to, that is the Daubert standard, the theory of holdup and royalty stacking that is the predicate for its business review letter would not pass muster. It's simply not sufficiently theoretically robust, and it lacks any empirical substantiation whatsoever. The other thing, and coming back now to the point about the possibility for collaboration among buyers of technology inputs to engage in behavior that would artificially suppress the price of patent holders, I think it's important to recall that about 25% of the price-fixing cases that are brought by the Antitrust Division actually are buyer cartel cases. There are many in agriculture, for example. And there was a very prominent one within the last year or so in Silicon Valley among many of the companies that are big proponents of patent holdup and royalty stacking regarding agreements not to compete for one another's talent. In other words, agreeing not to compete in the labor market in the tech sector. So I don't think it's at all hard to fathom that when it comes to buying the technology inputs, that a risk of collusive behavior is something that should be taken seriously. And the fact that the Justice Department didn't address it in its letter, I think, is troubling. Where does this lead us? I think that there's a serious problem, or serious possibility, I should say, that the SSO model, if it is going to be changed through the helpful suggestions of antitrust enforcement agencies, is not going to survive, and that we'll have to evolve to something else. I don't know what that would be, but it's not the only way to monetize intellectual property. And if the prospects of firms that are in the business of being repeat innovators is confronted by the prospect that their returns will be reduced by an order of magnitude or more, the natural thing to expect is that the market will produce some new business structure for commercializing intellectual property and seeing that it is compensated on terms that provide a continuing incentive for it to be brought forward. I'll stop there.
Thank you. Before posing questions and asking questions from the audience, let's see if anyone wants to comment on what any of our three presenters wants to make an additional comment.
I vote to open up the floor.
Okay. Yes, ma'am.
Hi. Oh. Hi, Leah Nyland from MLEX. I would like to, as Commissioner Wright said, recall the purpose of business review letter, which is for the Department of Justice to state its enforcement intentions with relation to a particular piece of conduct, in this case, I guess, updating their patent policy. I get that you guys don't like that the 90% of her discussion in there that involved patents and everything, but do you think that the Department of Justice got it wrong? Do you think that this represents an antitrust violation? And I understand that there's probably some sort of statutory reason why it couldn't go to the FTC, but if it had gone to the FTC, do you think they would have come to a different conclusion?
I take it the FTC one's for me. You know, I think you know, Leah, my ability to forecast what the majority of the commission does, you know, is limited. But I can give my own views, and let me sort of say a couple of things. You know, sort of with respect to my own views. One, I don't have the proposed changes in front of me to judge. My own view is that if by did they get it right, you mean do I think there's an antitrust violation, which I think is what you mean. No. I think that IEEE is you know, the antitrust laws place very narrow limits on what an organization can or cannot do. I think in the area of unilateral conduct, this is limited to deception. I don't think the letter says we plan on committing fraud or our members plan on committing fraud. What do you think about that? If I miss that line, then I will revise my opinion later. So with respect to unilateral conduct, which the letter is focused on, no. I don't think there's nothing in the letter that gives me any reason to believe that there's anything that violates the law. With respect to Section 1 type concerns, the types of things that Greg is talking about, with horizontal coordination. I think doing that analysis would require access to facts that I don't have sitting before you now. I mean, that requires things that aren't in the letter, right? To assess what kind of agreements to do what between whom, and I have no interest in speculating. But I don't think that whether they got it right or wrong in terms of the antitrust analysis is really that important. I think what's important is in terms of the real-world impact of the letter is, when you espouse a policy view, it applies to more than IEEE. It applies to everybody that's got a patent. Much of what's in that letter has nothing to do with even standard-setting bodies. I mean, the division apparently thinks injunctions are bad, and that's fine. But espousing that kind of policy view, I mean, the bang for your buck on that policy view being propagated throughout the patent system, as opposed to whether or not there are antitrust concerns with respect to IEEE, with respect to this letter, with respect to those amendments. I think one of those is the tail, and one of those is the dog, and it's the tail's the letter.
Just if I could just add one point, which is, I think it would be an interesting exercise for you or anybody else. I've done this exercise already. To put this business review letter in context, go back and look at other potentially analogous or related types of business review letters. And the two that come to my mind immediately, relatively recently, there was a business review letter about an organization called IPXI, IPXI. And some years ago, there was a business review letter on the third generation patent platform, 3G3P, not to be confused with 3GPP. And the only point that I'm making here is, if you go back and you look at those two business review letters, and they came out in different ways, the rigor of the discussion, I think, is starkly different than what we see here. And I think it does go into some of the points that Commissioner Wright and Greg were talking about, of looking at at least the potential of for example, the dynamic inefficiencies or potential for anti-competitive risk, and then coming to a reasoned determination whether that creates a no present intent or some other position. And I think that's what is particularly curious to me. And we can have all kind of conspiracy theorists and all that kind of stuff, as how this started at the remarks at the ITU and then resulted here, but that's not relevant either, and I will reserve my judgment on whether I think they got it wrong or right. That's neither here nor there.
Yes, Roy Hoffinger of Qualcomm, I believe.
Thank you, and thanks, Alden, for arranging this. And if it's okay with you, I'd like to address this to all the panelists. And it's prompted by, in the first instance, Greg's comments about buyer cartel behavior, but also then Commissioner Wright's reference to unilateral conduct. And so my question to the three of you is from the perspective of what not individual licensors do, but from the perspective of these policy changes at IEEE, are they properly viewed as, are those policy changes, is that unilateral conduct, or is it coordinated action? I'd be interested, with Alden's permission, of hearing from all of you on that.
Well, I'll start. I would view it as coordinated action because, well, I'll let Richard speak for himself, but he was describing substantial dissent within the IEEE, and I understand some kind of suspension of a consensus decision rule for the changes.
My view is that, one, definition of conspiratorial conduct in the context of of SSOs, I should say, generally, raises a number of issues. And I think, again, looking at how these facts or these circumstances evolve, there is clearly a point of view that was being advocated by certain interests. And part of the, I think, response by the IEEE as well, though, we have individual members. We don't have corporate members. So there's a factual issue, but I think if the evidence were to be viewed, and I'll put it in the context of a hypothetical lawsuit, I think there is a more than colorable basis to allege a conspiracy here. And I think not all agreements are necessarily anti-competitive or violate the antitrust laws. So that's there's a different issue of whether it's an anti-competitive agreement. But I certainly think that there's more than colorable bases to allege a conspiracy.
For very obvious reasons, I'm going to sort of double down on my not having any view, colorable, plausible, or otherwise, on what violates what law from whom and who should sue who. However, to the extent as whether the conduct in question in the letter should be thought of from an antitrust perspective as coordinated or unilateral, it depends, right? So, and part of the conflation between actual antitrust analysis and policy, I think, generates confusion on this point in the letter, right? So most of the policy talk is about unilateral conduct, and most of the legal talk is about coordination of some sort, right? So there's no problem with the process, so there's no Section 1 issue, we're done. So most of the legal discussion has in mind some kind of coordination, but the rest of the letter is aimed really at, is it good or bad for the world if we don't allow folks unilaterally to get injunctions after these policies go into place, right? The type of conduct in mind is unilateral, right? This is the type of case that sort of think Rambus or that other one in the Third Circuit, right? I think that is what's in mind in the policy discussion. I have no idea. You have to ask Renata, I think, but I think in the policy discussion, clearly what's in mind is unilateral. But it's what's actually proposed for review is coordinated action to change some contract terms. I think is perfectly fair to say that if I was in my old job as a law professor and someone got this hypo and didn't address Section 1, they would not get a good grade.
Fair enough. Thank you.
I think we have an additional question.
Hi, I'm Bill Wichterman. I represent Qualcomm. There are many who contend that what's actually driving this debate is a fundamental division in the world between those who are primarily in the innovative sector and those who are in the patent using sector, and that this would have this change, among others, being contemplated, have been undertaken in the courts, being contemplated on Capitol Hill, would have the impact of shifting that incentive structure a little bit more to the copying, you could call it thievery side, away from the innovative side. Love your reflections on whether or not you think that's a valid analysis.
I think it's very reminiscent of the intense debate over the pricing of network access after the 1996 Telecom Act, where we had these incredibly complicated rules for the network operator to make its assets available for use by aspiring competitors, and how the details of those pricing rules would actually work had huge implications for the business models of the entrants and the potential continued profitability of the incumbents. It was very litigious. It went to the Supreme Court in at least 3 different cases. The D.C. Circuit was involved over a course of 10 years. And ultimately, the issues could not be resolved. And the issue essentially went away when the old AT&T and the old MCI, which were the principal beneficiaries of those pricing rules, were acquired by the Bell companies, which were the principal companies providing access. So I hate to be a wet blanket, but these kinds of pricing disputes don't quickly get resolved through litigation.
I would just add that one, I'm not sure that it's possible to easily categorize different things. I think that the complexity of the marketplace is very significant. But I would say that from a broader context, and again to use some historical references, one, these issues are not new. Two, what we're seeing in the SSOs is one avenue. What we're seeing, and this is my personal view, in what have been called the patent wars, is not something necessarily directed towards getting the right legal answer, but it's another forum for the debate on business model and competitive success. Who will be able to sell the most tablets in the marketplace? The Hill is another place. There's all these different forms where ultimately it is to advance a business strategy. And having been looking at these issues for, well, it is 35 years, but and going back to when AT&T was divested on January 1st, 1984. And getting involved in these types of standards battles there. I was commenting to Alden earlier that in 1986, we had the same battle because AT&T had all the patents and MCI had none of the patents. And then in 1988, there was the AT&T Patent Crisis Conference that we spoke at. And, it's a much more sophisticated discussion. There used to be me and like two other lawyers that used to deal with this in the 1980s. Now there's too much competition amongst the lawyers, and a lot of economists are involved as well. But so I think that's the kind of context we need to look at it, and it's why, in my personal views, the actions reflected by the BRL are particularly curious and disturbing in some respects.
Let me just add one thought to that about the difference from some of these previous experiences. It's international now. And there, all of these additional enforcement agencies and industrial policy agencies, if you will, around the world. And so the implications of some action here in the United States for reactions abroad is very, very great.
The only thing I would add in terms of sort of causes and consequences of sort of this divide. I mean, certainly the disputes are manifesting themselves and things like this right now, but I think there's a very interesting historical trend with the antitrust agencies with respect to this intersection of antitrust IP sort of over time. I think if you go back into the old days of antitrust and IP was really easy. If there was a conflict, every opinion in the world said, antitrust grants patents makes monopolies, antitrust prevents them, there's a conflict, who wins, patent law, game over. It's easy to do antitrust. And that was fine. In that view, as antitrust law changed to become sort of conscious of the effects of conduct rather than categorizing things in boxes and so forth, became a coherent body of law. Eventually, I think there was a recognition that the fact that there probably is a patent on the ridges in this bottle doesn't mean it doesn't compete against other things I can drink my water out of. And so that what we ought to think about in terms of reconciling antitrust and IP are consumer welfare effects, right? We use economics as a tool to tie the branches together and talk about things like the trade-offs between static and dynamic efficiencies and so forth. There became so much consensus on this idea that we really cared about strong IP rights from within antitrust, that by 1995 the agencies put out guidelines that said, the starting proposition of the guidelines are IP rights get treated like real property rights in antitrust. That is principle number one of the guidelines. that IP rights and real property rights are to be treated in parity. And one of the main advantages of that approach is it said, we've got this toolkit for doing real antitrust analysis, and we're not going to have special rules for IP. Intellectual business models involving IP, we're going to analyze. We care about consumer welfare effects, and we're going to build our antitrust doctrine around that. I think that the trend now, and the reason I sort of hesitate to jump on the implementers versus innovators sort of narrative is I think the trend certainly has some of that component in it, to be sure, but I think is broader intellectually in the sense that since 1995, I mean, if you look at the antitrust agencies over the past 10 years, you have got going from the business review letter backwards, you've got DOJ consents and mergers involving transfers of patent rights that essentially say because we're concerned about holdup, we're going to impose merger remedies, right? We're going to extract consent decrees that are based on the same sort of theoretical concerns. At my agency, you've got the use of our special statute, our unfair methods of competition authority, saying that despite the fact I told you no Sherman Act case that ever has held patent holdup to violate the Sherman Act in the absence of deception, we have found breach of FRAND agreements to be unfair methods of competition and got injunctions in Google and Bosch, and before that Data, which was an especially controversial one. We have, to some extent, created special rules for IP. I think that that's slowly been happening. Why the sort of, is it the views in these 2007 papers, or is it something deeper than that about intellectual properties that driving it? I don't know, but is it there for sure? Data, Google, Bosch, Business Review Letter, merger consent decrees at DOJ. Beyond that, in the pharma context. In the pharma context right now, post-activists, what's the rule of reason for reverse payment settlements involving pharmaceuticals? We've got a special rule for how to do the rule of reason. If the payment's bigger than litigation costs, we've got a violation. Doesn't sound like any rule of reason I've ever seen before. It doesn't talk about type 1 errors and type 2 errors and cost to consumers. It just says if the payment's bigger than X, plaintiff wins. I think there's inherent skepticism about patents that's driving some of that, but I think it's clear that we've deviated from the parity principles that are in the guidelines. I don't think anybody, you can certainly point to examples at both agencies that suggest that we're not following them.
Okay, well, that was excellent summary, and that will be the last word, unfortunately, and thank you for our panelists for most spirited and enlightening discussion.